The petitioner is allowed to go on bail of rupees 1 lakh with 2 sureties of like amount with certain conditions.
Considered case trial is going on, but petitioner behind the bar 532 days, my lord.
No, offense is under postcode.
But
Oh,
at this,
so,
yes, my lord. Notice may go, my lord.
heard Mr. R. Islam, learned counsel for the petitioner. Also heard Mr. P. Borthakur, learned additional public prosecutor. This application under section 430, 483 of BNSS, 2023 has been filed by the petitioner, namely Rafiqul Islam, who has been detained behind the bars since 4/7/2023. How many days?
532 days.
Within bracket for 532 days in connection with special case number 180/2023 arising out of the BPS case number 266/2023 under section 365/376 DA/306 of the Indian Penal Code, read with section 6 of the POCSO Act. Issue notice to the respondents. Since an additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued. As regards respondent number 2 is concerned, notice shall be issued in pursuant to the relevant notification in that regard. The petitioner shall take steps for issuance of notice on the respondent number 2. What stage the trial is pending now?
My lord, 8 number of PW already examined.
Over.
8.8.
The perusal of scanned copy of the case record of special case number 180/2023 may be required. Is felt necessary for consideration of the instant bail application. Hence, same may be called for registry to take steps for requisitioning the scanned copy. Let this matter be listed.
My lord,
With
co-accused bail petition is pending, my lord, that is 3rd January. Yes.
but notice has to be served.
Yes, notice may go, my lord.
Let this matter be listed again on 3rd of January.
I will advise.
May I please tell the truth? But in this case,
Yes, oh,
Item number
five. Five.
Okay.
Well, in this case, my lord, co-accused have been granted bail on 11/11/2024 by your lordship, my lord. I'd like to file this compilation.
on what grounds?
Grounds of delay grounds, my lord. Same
Delay or
peti-
prolonged incarceration.
Following introduction. This petition is the order, my lord. Same footing, both were arrested.
Abdul Hasib.
When he was granted bail,
He was granted bail 11/11/2024.
this is the order.
Is the order, my lord.
What is the, what FIR says?
FIR says, my lord, is the carrying of some contraband. Seven.
What has been recovered?
Recovered, my lord, 739
739.01 grams of heroin.
Heroin
Yes.
grams.
from your possession.
Not from the three,
Yes, ma'am.
position
From
of three
position of
person.
3% and he is one of the accused.
Yes, sir. Person of three persons. Zamiruddin, Zubair Ahmed, Abdul Hasib.
Since when you are behind the bars?
I am 19/12/2022.
22.
Yes.
1 year.
is 1712. 2 years almost.
Yes, make your submissions.
So, my lord, in this case, undoubtedly it is a commercial quantity. However, my lord, I am saying the ground I have taken, this paragraph 7, page 5, like, that the petitioner begs to state that with bona fide intention, two persons boarded the vehicle with some materials. When police.
How many witnesses
No,
are
witness.
listed?
My lord, total 8 numbers of witnesses, my
How
lord.
many have been
Two-
examined?
Two independent, my lord.
No one is examined.
No one has been
No one
examined.
is.
Anything else?
So, my lord, my submission, my lord, purely, my lord,
Yes, Mr. Bhattakur.
Yes, article.
Otherwise, my lord, first of all, my lord, regarding parity, my lord, Supreme Court, my lord,
No parity.
parity. So, my lord, parity, now, my lord, regarding, my lord, long incarceration, my lord.
No, regarding parity, what Supreme Court has
Said
said?
that parity cannot be a ground, my lord, this type of offences to, my lord, here, my lord, state of Bihar.
Where it has stated?
My lord, state of Bihar versus Amit Kumar, my lord,
What has been stated?
2017.
No, what has been stated regarding parity?
My lord, in this type of, my lord, heinous offense, because these are the, my lord, NDP.
No, suppose in a heinous offense, an accused is, two accused are placed under similar circumstances.
Yes.
Similar charges are there.
Yes, my lord.
One has been granted bail,
Yes, my lord.
whether other can be denied bail.
My lord, under
Whether-
that circumstances, whether the entire facts and circumstances has to.
Are similar or not,
Yes,
that has to be seen.
evaluated, my lord.
If they are situated in similar circumstances, then parity is a ground which may be taken up. Supreme Court said that parity in itself, parity has to be proved,
Yes, my lord.
that they stand in same circumstances.
Here, yes, my lord. Here, my lord, the present petitioner, my lord, case of the present, earlier, my lord, your lordship on 11/11/24, your lordship has rejected the bail petition of the petitioner. At the,
Oh, his petition prayer was rejected on 11/11.
No, my, on 11/11, the co-accused bail application was granted, my, Zamiruddin. I am not Zamiruddin, I am Abdullah.
When your prayer was rejected earlier,
My.
no, my lord, sorry, that was in the case of one Zamiruddin, my lord, not.
Zamiruddin.
But later on, my lord, Zamiruddin was allowed by your lordship on 11/11/24, my lord.
Okay.
On that, in that petition, my lord, he has taken two ground regarding long incarceration and non-compliance of 52A. At that point of time, your lordship has rejected both the grounds of the accused petitioner, Zamiruddin. In case of the Zamiruddin, my lord,
no, ultimately Jamiruddin has been allowed.
ultimately, Zamiruddin has been granted bail, my lord. And regarding long incarceration, my lord, because that ground has been taken by the petitioner, regarding that, my lord, I would like to place, my lord, some of the judgments of this Honorable Supreme Court also, and my lord, some of the judgment orders of the my coordinate bench of this Honorable Court also, my lord.
Yes, what points?
Your lordship may kindly.
No, you have to point out so
Yes,
that
sir.
I can deal with them.
And here, yes, one of the judgment of the state of Meghalaya versus, my lord, Lalin Tuangla Silo and another, my lord, that is special leave petition 1602123.
What it has been,
My
what
lord,
has been,
paragraph 10 and 11, my lord. Here in that case, my lord, the accused petitioner is, my lord, one HIV patient. In that ground, on that ground also, my lord, learned Supreme Court has rejected his bail petition, my lord, on the ground of parity. Your lordship may kindly.
no,
prove-
but he's not he's not
Yeah.
taking that ground. Mr. Upadhyay, he's not taking that ground. He's taking ground of prolonged incarceration.
Yes, my lord. In this case also, my lord,
In Rajasthan, state of Rajasthan.
no, my lord, this is the state of Meghalaya versus, my lord, El Silo and another.
Which is that? You give me a copy. You have two copies.
Yes, my lord. Let me have a look. No, sir. Payment copy available. No.
It's which para?
Paragraph 10 and 11, my lord.
What it says? Para 10 and 11 you are relying.
Yes, my lord.
What it says, 11 and 10?
On that ground, my lord, he is only taking the ground of, she is suffering from SIB. And
But in this case, HIV is not a ground.
yes, my lord.
Then why are you relying this judgment on this judgment? In that case also, my lord, and long person is behind the bar since long, my lord. Although, my lord, I would, my lord, sorry, my lord, regarding in that aspect, my lord, yes, in that case, my lord, only ground of, on the other hand, my lord, at that point of time, my lord, the person was also, and although, my lord, I will point out, my lord, other judgments, decisions of the, my lord, coordinate bench of this honorable court and one another decision, my lord, of the Supreme This
Court.
you are not relying.
Yes, my lord, at this point, I am not relying because, my lord, I will have to go through in detail.
Which
my lord.
other judgment you are relying?
Judgments, my lord.
Are you ready today?
Tomorrow, your lordship, if your lordship, but then I will, my lord, specifically point out, my lord, on the
Yes,
ground
you
of
come prepared.
long incarceration, my lord, because in many
What are
cases.
the observation against
Yes, my lord.
granting
And my
bail?
lord, I will also point out your lordship, my lord, regarding speedy trial and how they are, my lord, the present accused person prejudice in, and whether the, in case of the petitioner, whether section
No,
Article 21 of the petitioner is violated and whether petitioner, my lord, on the ground of violation of Article 21 and my lord, while pointing out, my lord, Husainara Khatun and my lord, Muhammad Muslim also, I will point out, my lord, in this type of offenses. my
let
lord-
me put my query.
Yes, my lord.
My query is, the petitioner has taken specific ground that he has been detained behind the bar since last 2 years
2 years, yes.
and not even a single witness has been examined.
Yes, my lord.
In this regard, there are some observations of
And
Supreme
here
Court.
will some difficulties there, my lord, because
No,
only
you listen to my
yes,
query.
yes,
Then
ma'am.
only you can help me.
Yes, ma'am.
Observation of Supreme Court that under such circumstances, the fundamental right of the petitioner guaranteed under Article 21
21.
overrides the embargo of
Yes.
37. That means in spite of 37 there being in the statute book, it will be ignored if there
Yes.
is a prolonged incarceration.
Incarceration, yes, ma'am.
If you want to help overcome this observation, you have to show some,
And my lord, I would just, my lord, like to point out one,
not today, not today.
yes,
You-
one paragraph of the Muhammad Muslim. In that case, my lord,
I'm not listening to you today.
yes, yes, ma'am.
You come prepared. His ground is very specific.
Specific, yes,
Otherwise, he will not get bail. If you
Yes.
can overcome this,
yes, ma'am.
that there is some observation which overrides the observation made by Apex Court in these judgments which are cited by him.
Yes, ma'am.
Okay,
Day after tomorrow.
okay, come day after tomorrow. Third, Mr. HR Chaudhary, and counsel for the petitioner. Also, Mr. P. Borthakur, an additional public prosecutor, who prays for some time to bring certain authorities in support of his submissions. Prayer is allowed. Let this matter be listed. Day after tomorrow is 1912.
No, 6 also, my lord, on the same ground, my lord, long incarceration. my lord.
And you are not ready.
My lord, in this matter, I am behind the bar for 2 years, 1 month, 5 days as of today, my lord, which stands at 766 days. And Lordship was earlier pleased to grant the bail of
How many witnesses have been examined?
Now three, my lord, three witnesses examined.
yes, 10 listed 10 witnesses are there, my lord. 3 witnesses have been examined, my lord, in this matter, and it has been 2 years, 1 month, my lord.
Mr. Bhattakur, you have to show that in spite of prolonged
Incarceration,
incarceration,
yes, ma'am.
bail can be refused in in a case involving offense under NDPS case.
Yes, ma'am.
That much you have to show.
Yes, ma'am.
Day after tomorrow.
Yes, my lord. In fact, my lord, there are very recent judgments of Honorable Supreme Court where our Honorable High Court rejected the bail applications because of the bar of Section 37, my lord. I will place these orders when matter is fixed, my lord. The Supreme Court in one occasion granted bail that the accused has the right to speedy trial. That is in consonance with the Section 36, my lord, 36 of NDPS Act, which, my lord, if I may just, madam, one line.
No, Supreme Court observed.
Yes, my lord, that the accused has a right to speedy trial. So on that count, my lord, he was granted bail. In another case, my lord, only there were 5 witnesses to be examined by the prosecution. 3 were examined. Our Honorable High Court rejected the bail application. Supreme Court, my lord, granted the bail, saying that, my lord, that he has spent 1 year, 6 months, and there has been examination of witness, so he has a right to get bail, my lord. I will place these, but these are very recent orders, my lord.
Okay.
Yes.
You also place counter sign.
Otherwise, my lord, in these two cases, some difficulty is there because, my lord,
Trial has not yet started.
started my here in this case, 3 witnesses examined. Earlier case, item number 5, my lord, trial not yet started. And my lord, regarding my lord, other some of the problem
Then,
is
then let
because-
them go on bail. You ensure their presence.
try to point out on day after tomorrow, my lord.
Okay.
If
Third
I do not
image.
find anything, then my lord.
Heard Mr. M.A. Chaudhary, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional public prosecutor, who seeks some time to bring some authorities on which he would be relying while making his submission in this case. The prayer is allowed. Let this matter be listed on 19th of December.
Deeply obliged, Lordship.
Nay, please, your lordship. This is an anticipatory bail application, lordship.
Is
Here,
there
FIR
is there?
Case area available.
here FIR is on page 14, lordship. And co-accused lordship arrested in this case, she was granted bail, lordship. The quantity recovered from the co-accused lordship, it is specific 2.28 gram, which is less than small quantity also, lordship.
Oh. Now you said that less than small quantity is
Now,
available.
bailable that our coordinate bench has found that because lordship 37 may take to lordship to the 36 first lordship.
However,
No, if it is bailable,
otherwise, my
But-
lord, act is very clear, my lord. All offences under NDPS Act are non-bailable.
all
cognizable.
offenses.
No lordship. Kindly peruse 37, section 37. That's why I'm saying to lordship, kindly peruse 37. lordship.
No, in Riya Chakravarti's case,
Yes.
apex courts observed that all offenses are not apex court.
Bombay High Court,
Bombay High
we say
Court.
Bombay High
Bombay
Court
High
say in all offense under this act is a non-bailable offense. But lordship 37 statute say lordship, it is say, may I read lordship that 37 lordship.
Yes.
Heading say offense to be cognizable and non-bailable. What is the body of that headline lordship stated? 1. Notwithstanding anything contained in the Code of Criminal Procedures 1973, every offense punishable under this act shall be cognizable. There is no dispute on that, lordship.
Yes.
But they have not specified, lordship, whether it is non-bailable or not.
Apart
So-
from heading, there is nothing.
Nothing.
So which offenses are bailable, which are non-bailable?
That lordship section B says, lordship, specifically they are dealing with the release on bail, lordship. And it is specifically stated about the commercial quantity, lordship. The embargo 37 will be applicable.
So the word non-bailable used in heading of section 37 relates only to 1924-27A
Yes,
and
Lord.
commercial quantity
Yes,
that you
Lord.
want to say.
Yes, Lordship. And moreover, the Lordship, this offence is travelled by the magistrate court, Lordship. That's why, Lordship, may I take Lordship to 36A. Subclause 1, subclause A.
What it says.
Offence tribal by a special court, notwithstanding anything contained in the Code of Criminal Procedure Code. A, all offence under this act which are punishable with the imprisonment for a term more than 3 years shall be tribal only by the special court. More than 3 years. Here, Lordship, small quantity as defined as.
No, no. Here we are not concerned about that issue.
But-
By which court it is tribal. Here we are concerned about whether it is bailable or non-bailable.
Yes, Lordship. Bailable, since it is a silent in the statute, Lordship, it will be considered to be an bailable one, Lordship.
Why?
Because, Lordship, other things is specified there, Lordship.
Where?
Regarding, Lordship, release on
No,
bail.
whether now BNSS would be applicable in this case.
A PNSS, that.
Schedule of BNSS. Is provided in
75, 78.
regarding bailable or non-bailable. What is the provision?
Today I don't have the PNSS. in the Lordship.
Schedule 2. No. First schedule, that if the offense is punishable for less than 3 years with fine, the offense is non-cognizable and bailable. Here specifically the statute makes every offense as cognizable. But apart from use of the word non-bailable in heading, it does not use in the body of the section.
Yes, Lordship.
So if it is bailable, then when anticipatory bail is
That observation,
Maintainable.
because coordinate bench already been held, Lordship, it is a bailable, Lordship, that order.
so,
Lordship.
okay, if I am also holding it to be bailable,
Yes, Lordship.
then your application is not maintainable.
Then direction may be given to approach before the court below, Lordship. The court will consider since it is available. That speaking order will help this petitioner, Lordship. But otherwise, the court below will not consider these things.
Now, whether charge sheet has been laid,
That
No,
case
my
diary
lord.
is there, Lordship.
Case diary is available. Earlier, your lordship has allowed the bail
Co-accused
petition of
regular
the
bail.
application of the, my lord, wife of the present petitioner. And in that bail petition, your lordship has specifically, my lord, observed that the main allegation is against the present petitioner. So on that ground only, my lord, the wife of the present petitioner was allowed.
now
to
what
bail.
is your submission regarding bail?
My
for
submission
non-bail?
is that, my lord, in this case, this is not a fit case for granting anticipatory bail, my lord. Because, my lord, earlier, your lordship.
No,
observed-
whether maintainable anticipatory bail is,
And they say if, my lord, not non-bailable, then, my lord, in that case, my lord, bailable offense, then in that case, my lord, this anticipated.
is
bail
there
is
any
not-
apex court ruling on this?
But, my lord,
No, Lordship,
while he has raised a legal issue, my lord, I will have to also go through it,
Yes.
my lord.
Is there any apex court ruling?
No, Lordship, I didn't. find
Because
it.
there are rulings of other high courts
Bombay High Court is there, Lordship. Bombay High Court is
saying
there.
it non-bailable.
And he said non-bailable, Lordship.
You find out because if I hold it to be bailable,
Yes, Lord.
one of the coordinate
Yes.
bench has
Yes, Lord.
already held it to be bailable.
Yes, Lordship.
So whether I agree with it, if I disagree, then
Yes,
it has to be referred to larger bench.
Lordship,
Yes.
regarding that things, Lordship,
If I agree,
Mm.
then I have to issue
Then
directly.
I will also have to point out to your lordship. my
but
lord,
one
because-
paragraph from, it
Yes.
is not related to the Lordship, the NDPS Act, but where in Kalyan Chandra
Otherwise, my
Sarkar
lord-
versus Rajesh Ranjan Lordship. And that is reported 2005 to Supreme Court, case 42 Lordship, where paragraph 19 say the principle of res judicata and
Mhm.
such as analogous.
Otherwise, my lord,
Because
every offense
coordinate-
under this
let-
act are
one line,
non.
Lordship, may I read that? May I consider or not, Lordship, subject. The principle of res judicata and such analogous principle, although are not applicable in criminal proceeding, still the court are bound by the doctrine of the judicial discipline, having regard to the hierarchical system prevailing in our country. The finding of a higher court or a coordinate bench must receive serious consideration.
No, therefore I'm
Yes.
saying if I agree with the coordinate bench,
Yes, Lord.
then the order may be in your favor. If I disagree, the
Yes, Lord.
option to disagree is there,
Yes, Lord.
then I have to refer it to larger bench.
Yes, Lord.
So I have to hear this on this. You come prepared.
Yes, my lord. Anticipatory bail, my lord, after vacation.
No, no,
Not
why
after
should I?
vacation.
Dear, why do you
Give me
after
time to-
vacation? There is no protection, Lordship.
You-
Because
then on
recovery
nine-
is,
on
Lordship.
the last date, on the last day.
Yes. So for recovery is concerned, it is from the wife, Lordship,
My
not
lord,
from
on
the
Thursday, my lord. on
concise position of
Friday,
this
I may not be
petitioner.
available.
On Thursday,
Thursday, no.
heard Mr. B. Chaudhary, learned counsel for the,
Otherwise, my argument
Petitioner.
offenses under this act are non-bailable. my lord.
also heard Mr. P. Bhattakur, learned additional public prosecutor, learned counsel for the petitioner raised the plea that in the may, learned counsel for the petitioner made submission that the quantity of contraband recovered in this case is of how much?
2.28 grams.
2.28 gram, which is a small quantity of heroin.
Heroin.
He submits that considering the quantity of contraband recovered and punishment prescribed for the alleged offense, the offense involved would be a bailable offense. Stop. On this, learned additional public prosecutor submits that NDPS Act provides, Section 37 of NDPS Act provides that all offenses under NDPS Act are cognizable as well as non-bailable.
Yes, sir.
He also submits that he may be allowed some time to produce certain authorities in support of submissions made by him. The prayer is allowed. Let this case be listed again on 1912. You also bring
Yes.
some authorities.
Well, one thing Lordship will appreciate, Lordship thinks is that since regarding bail, Lordship, it is silent, the CRPC will be follow up. Now BNS will be follow up.
No, that you have to make
Yes,
assist
Lord.
this court on.
Because the CRPC has overriding effect on this special act, Lordship.
Yes, on Thursday.
Obviously.
Yes.
Your lordship order, my lord, 3724, my lord. My lord, page 26, lordship.
Why this review petition has been filed?
My lord, the court while switching the second appeal, my lord, observed that the question was not raised before the trial or first appeal of court. That the suit land and the land mentioned in the power of attorney is not the same.
Whether on that ground the second appeal was rejected, told,
No.
or whether there were other grounds.
Other grounds are there. Now, apart from this, my lord, PW one, the Ajit Ghosh. Suit, the suit, my lord,
No, what are your grounds for preferring this review?
my
That
lord, round three. was-
one wrong observation was made.
My lord, round three and
Which
four.
was that observation?
My lord, round three and round four, my lord. Page 6.
Page 6 of your review.
My lord.
Yes, please. Read.
My lord, what that the honorable court by the opposite judgment and order dated 37/24, this honorable court observed that the points of law raised by the appellant in the second appeal were not raised by the appellant before the first appellate court. But a reading of memo of appeal of the first appellate court, where in round 19, the point was raised before the lower appellate court, as such the judgment is required to be reviewed by this honorable court. My lord, I have annexed the memo of appeal, my lord, of first appellate court, page 17, my lord. It's ground number 19. Page 1, sir. Lordship.
Page 17.
17, 1, sir. For that the schedule of the land described in the general power of attorney can by no stretch of imagination be treated as the land under suit. Lordship.
Yes.
Okay.
Yes.
My lord, apart from this, my lord, in the plain, my lord, the number was mentioned, lordship, 1855 and 1857. Whereas PW1 Ajit Ghosh, my lord, in his cross-examination, he has stated, my lord, the numbers 1356.
So,
So, my lord, the suit land and the sale deed by which I purchased the land is different. And this observation, my lord, that this question was not raised before the first appellate court, but it was very much there. And that was also a substantial question of law before the honorable court by the second appeal of it.
no. You submit, you make your submission as to how, while considering the substantial question of law, while disposing of the second appeal,
Lordship.
this court made some error which is apparent on the face of
Yes,
record.
Lordship. So only, my lord, this ground 3, my
Ground 3.
lordship.
Yes. Anything else?
This is only.
Yes, Mr. Chakravarti.
Lordship, the ground should be apparent on the notice for my, it should not be with a full length hearing. What he's raising is maybe ground for appeal before the High Court. But that is cannot be the apparent on the face of the record, and that aspect has been your lordship has dealt with in spite of that.
Where?
Paragraph 23, page 27. All this aspect has been dealt with. So it's not an error apparent on the face of the which can be seen by immediately looking into the records.
No, what he has raised, which ground? That,
That the schedule of power of attorney and the plaint are different.
Ah.
That aspect has been dealt with. And your lordship has held that in spite of that, even assuming that, but he has not challenged it has been held that the signature of the sale deed is different. In spite of if lordship has dealt with that, if it is also allowed, does not make any difference. That your observation, your lordship will
Where?
have.
where?
Because he has not called the handwriting expert to examine him after he has rendered his opinion.
What was the substantial question of law which was there in the second appeal?
My letter. Lordship is.
Lordship, page 26, paragraph 21. Whether the courts below were justified in declaring the suit of the plaintiff institute of power of attorney holder without recording any finding as to whether the schedule of the power of attorney, exhibit A and the schedule of the bill is the same property. Lordship will discuss elaborately in paragraph 23, 24, and 26. Twenty-eight also. And at paragraph, at page 30, the concluding line of paragraph 29, your lordship has held that as such circumstance, the outcome of the substantial question of law formulated by the court would not in any manner affect the merit and finding error by the courts below on the validity that impugned sale deed which is directed to be cancelled by the impugned judgment. So it's already held.
Okay,
has
I will
been
go
held.
through it.
So it's not a case of this, which has your lordship will exercise
Friday,
power of a review.
Friday I will pass out.
Yeah.
Heard Mr. J. Loskar, learned counsel for the review petitioner, also heard Mr. B. Chakravarti, learned counsel for the respondent. Let this case be listed for delivery of orders on 20 December 2020.
All right.